Hey, welcome. Today we're going to talk about something you can't see or touch, but it pretty much powers our entire creative world. I mean, from blockbuster movies to the logo on your phone. We're talking about intellectual property. It's the whole framework of ideas, brands, and inventions that are worth billions. And today we are going to break down exactly how it all works. So here's what we've got on top. We're going to kick things off with a pretty famous story from the music world that perfectly shows what happens when these IP rules get broken. Then we'll get into what intellectual property actually is, dive into the big three, that's copyright, trademarks, and patents, and we'll wrap up with the practical rules you really need to know for using content legally. All right, first up, let's get into the story of a stolen sound and a very, very pricey bass line. So let me ask you a question. Think about two massive hits, Under Pressure by Queen and David Bowie, and Ice Ice Baby by Vanilla Ice. Other than both being super catchy, what do you think they have in common? Well, let's just look at the timeline here. Under Pressure came out way back in 1981. Then, almost a decade later, in 1990, Vanilla Ice drops Ice Ice Baby, and it just explodes. It was actually the first hip-hop song to ever top the charts. But people who heard it noticed something kind of familiar. And here's where the problem started. That iconic bass line in Ice Ice Baby, it wasn't just similar. It was basically a perfect match to the one from Under Pressure. It was so recognizable, you just couldn't miss it. And that's when the trouble began. So the whole issue boiled down to this. Vanilla Ice never got permission to use that sample. No license, no phone call, nothing. The result? A legal showdown that ended up getting settled out of court. And the price for that mistake was steep. We're talking a hefty payment, and maybe even more importantly, having to give songwriting credit to David Bowie and all the members of Queen. This case is like the classic lesson in intellectual property. You know, that story is actually the perfect jumping off point to ask the bigger question. What even is intellectual property? We're diving into the world of billion-dollar ideas that you can't actually touch. Okay, so officially, intellectual property, or IP for short, is all about the intangible creations of your mind. See, it's not physical stuff like your car or your house. It's the legal ownership of ideas, brands, music, designs, all that creative work that has real value. And just how much value are we talking about here? I want you to take a look at this number. Over 200 times billion dollars. I mean, what on earth could be worth that much? Believe it or not, that number was the estimated value of just the brand of a single company, Apple, all the way back in 2019. Now, that's not their factories or their iPhones. That's the value of the logo, the name, and that feeling you get when you see their stuff. It's the loyalty and trust that brand represents. And all of that is protected as intellectual property. That's the kind of power we're talking about. So let's break this down a bit more, starting with the first major category, copyright. This is the big one that decides who owns all your photos, music, and movies. So copyright doesn't last forever, but man, it lasts a long time. For TV and radio broadcasts, it's 50 years from when it first aired. For most of the creative stuff like music, audio, and photos, it's 70 years from the first time it was published. And get this, for films, it's even longer. 70 years after the death of the main creative minds, the director, the writer, the composer. And here is a super important point that a lot of people actually get wrong. Your creative work, it's automatically protected by copyright the instant you create it. Doesn't matter if you snap a photo, write a song, or design a logo. You don't have to file any special paperwork or register it anywhere. Those rights are yours from the moment you make it. Okay, next up, let's talk about trademarks. This is all about guarding a brand's identity, really, through the power of a symbol or a name. You've definitely seen these two symbols around. That little TM symbol just means a company is claiming a name or logo as their trademark, but it's not officially registered. The R symbol, though, that's the big one. That means the trademark is legally registered with the government, which gives it much stronger nationwide legal protection. And this protection really matters. Here's a real-world example for you. The supermarket Asda tried to register the phrase "spec savings at Asda," but they were denied. Why? Because it was decided it was just too similar to the already registered trademark for Specsavers. The whole point of the law is to protect brands from this exact kind of confusion. All right, our third category is patents. Now, this isn't about songs or logos. This is all about protecting brand new inventions. It answers the question, how do you actually own an idea for something that works?
So, to get a patent, your invention basically has to clear three major hurdles. First, it has to be totally new. Never described publicly anywhere in the world. Second, it's got to be inventive, which means it can't just be some obvious little tweak to something that's already out there. And third, it has to be applicable. It needs to be something you can actually make or use in the real world.
It's also really important to know what you can't patent. You can't patent a scientific theory, for example, or artistic works like books and music. That's what copyright is for. You also can't patent medical treatments. Patents are specifically for tangible, physical inventions, not for abstract ideas or creative expression. Okay, so we've covered the what. Now let's get into the how. How do we share, use, and create things legally in a world that's just packed with copyrighted material? Let's clear up a really common term here, royalty-free. This does not mean it's free to use. Royalty-free just means you pay a one-time fee to get a license for an asset, like a stock photo. A traditional royalty model is totally different. That's where you're paying a little bit for every single use, like a fee for every copy of a book sold, or every time a song is downloaded. But traditional copyright isn't your only option. There's also this really flexible system called Creative Commons, which lets creators pick and choose how other people can use their work. BY means you have to give them credit. NC means you can't use it for commercial stuff. ND means no changing it, and SA, or share alike, means that if you create something new with it, your creation has to have the exact same license. It's a really powerful way to share things legally. And finally, there's one last important exception called fair dealing. This lets you use small bits of copyrighted work without permission, but, and this is a big but, only for specific things, like private study or non-commercial research. The key word here is fair. For instance, quoting a couple of sentences from a book for a review, that's probably fair dealing. Photocopying the whole chapter to give to your friends? Definitely not. It's really a rule of reason, not a free pass. So from music samples to brand logos to game-changing inventions, intellectual property is really the invisible engine that drives creativity and innovation. It's what makes sure that creators can actually be rewarded for their work. And that brings us to our final thought. Your ideas have value. The question for you is, how will you protect them?